Well, happy Sunday. How is everybody today? I repurposed this thumbnail, but I couldn't think of a better one for what I was trying to say. So I just added a picture, I added a Deadpool toy, a highlighter, and new words. Thanks, Jane. All right, I was just looking at the chat a little bit. So today's episode is actually recorded. But I wanted to do this live because I wanted to come on and talk with you a little bit before and a little bit after. Hey, Don't F with Justice. I think you'll like this one. So there's a bigger picture to my feelings about this judge. I think you all know how I feel about him, but there's a reason for that. It's not just I don't like his decisions. And with this particular episode, it took me several days worth of research. And the research that I did on this case, it just solidified the feelings that I have. It helped me put a finger on what's so bothersome to me about the situation. So what I'm going to do today is I'm going to walk through the documents about this deposition, starting from the motion for sanctions, the reply to it, and the order. We're going to talk about how weak Michael Gottlieb's arguments were. We're going to talk about how his case law didn't match the case. And then we're going to go into my own research into how fellow judges in the Southern District of New York have handled similar cases. And that's really the key to my feelings. It's not about what I think he should be doing. It's about what other judges are doing and how it's so different. This is a unique case. One side has all of the power, and that side is literally controlling the media. The way this judge openly shows his constant irritation with Brian Friedman specifically and Wayfarer, he's not nice to any of them. It's being picked up on. It's being picked up on by the media. And what kind of signal is this sending? A judge is supposed to be neutral. They're supposed to be there to represent the law, not to support one side over the other. How dangerous is it when your judge has this attitude of obvious irritation of one side and obvious favoritism to the other? He does not rule in the same way. He does not treat both sides the same way. And that's what he's supposed to be doing. And we're going to get a chance to see judges that are treating both sides the same. And that contrast between what we see with him and what we see with those other judges who ruled on very similar cases just really stands out to me. That was the biggest thing that I picked up in this research. Confessions said, I think that Manette and Brian have gone up against each other before, and they have bad blood. It's bigger than that. I'm actually diving into something that I kind of toyed with earlier, and then I backed out of it because it's not really about legal documents. It's more Hollywood sort of situations behind the scenes. But after this, I picked that project back up again last night and started reading through it. There was a situation between Judge Lyman's brother, Doug Lyman, the Hollywood director, and Brian Friedman, where they were on absolute opposites of something and speaking out publicly against the other's viewpoint. So it's convoluted and it's messy and there's billionaires, and so there's a lot of research I want to do, and it's not the typical thing that I usually feel comfortable reporting on. I feel comfortable reporting on something that is a public legal filing in a judicial proceeding. This is more like reports from magazines. So that's why I didn't really go far into it when I very first heard the story, just because I'm a little more of a cautious person. But now I just really want to dive into it and see what I can find that I can substantiate, and maybe even just do it with a banner saying, this information comes from this magazine and that magazine, and just report on it, because this man cannot stand Brian Friedman. And it's an odd position for a judge to take. It's not like he works with this man all the time. Brian Friedman operates almost exclusively out of California. And as far as I know, it's his first time ever having a case in this court. So what's going on here other than the situation with his brother? So it's very bothersome to me. Okay, and in this case, so sanctions were asked for in response to things that happened in a deposition. Now, he did technically deny the sanctions, but the only thing that he actually denied is that he didn't put big fines on anybody. The sanctions were requested for Brian Friedman and Kevin Fritz. What I think is very interesting is that the conduct that he actually addresses is the fact that Kevin Fritz felt that there was attorney-client privilege between conversations with the witness being deposed, Nicole Alexander, and counsel that she had spoken to before. He was being cautious. He said, "Don't answer these questions because it's about conversations with an attorney." Well, the judge has determined that he doesn't think that those are privileged. So the the conduct that he actually made a move on was to say that, and both parties apparently agreed to this, perhaps in the hearing that we didn't get a chance to hear, that they're going to do a 1 hour, like, supplemental deposition, just specifically aimed at the questions that he instructed her not to answer in an abundance of caution. That was Kevin Fritz. That wasn't Brian Friedman. There was an unpleasant conversation that was held. Meryl Gavernsky was in the wrong, and Brian Friedman stepped in and said something to correct her. She wouldn't back down. It escalated. We saw Ezra speaking out of turn. It's reported, all this stuff was reported to him by Kevin Fritz in his beautiful reply. He gave transcripts to this judge that seemed to have been completely ignored. There was lots of the same conduct that took place between multiple attorneys, but only Wayfarer was addressed, and only Brian Friedman was given a warning. Nothing was said to anyone else, though everyone had engaged in this kind of conduct. And that just really, really bothers me. Why does it bother me? Because, like I said, the media is watching everything and reporting on it. And we've seen the way Blake's team goes straight to the media. They feed them false information. These false stories come out. And who is hearing these stories? A lot of people who aren't on social media, who don't listen to people like me and all of the other brilliant content creators who are reporting on this and reporting it as truthfully as they can. They're out there hearing just what mainstream media has to say. And so, constantly seeing this judge with this attitude, what does it signal? That signal is the dangerous part, because amongst those people are potential jurors. that are going to sit on this trial. If they have already picked up on this judge's attitude, if they have already heard stuff on mainstream media, they may feel a certain way. Or if this is the way he's acting now, how is he going to preside over this trial? Because the way we've heard him in hearings and the voice, the tone in his orders, if he proceeds with that same attitude, the jury's going to pick up on that. And if they don't have the background and perspective, the jurors are not supposed to have a background where they have gone in detail and researched the case or know a lot of information about the case. So this man's decisions of what he's going to allow these attorneys to say in trial, what he's going to allow as evidence in this trial, how he's going to treat and speak to these people, the jury is going to see that. And that is the bigger picture. That is the danger. And that is what bothers me about this man. It isn't just he doesn't make decisions that I like. It's not that simple. It is so much bigger. And then when I was researching what other judges have done and said, that's when it really, really struck me. I was able to put my finger on why I feel so uncomfortable every time I catch this man's tone and see him not acting in a judicial, neutral manner. He cannot hide the way he feels about Brian Friedman and Wayfarer. And that's wrong. Exactly. The judge acts like he didn't know or care about these celebrities, but then why is he constantly catering to Blake? Is it because of Gottlieb? I want to know about their relationship too, like in private life. Gloria says and thank you, Gloria, very much. It reminds me of Johnny Depp in the UK. That judge was so biased against Johnny Depp and was also related to or had ties to the Sun newspaper. Here we see it again. Exactly. I think a whole lot more needs to go into looking at the backgrounds and the relationships between these people. If he doesn't like Brian Friedman because of something that happened with his brother, then recuse yourself. Don't take the case. If you have an obsession with Hollywood to the point that you've got a bunch of Hollywood stock and your dad used to represent MGM and Time Warner and ABC, recuse yourself. Don't take this case. Don't F with Justice says, yes, he ignored Prince's response and transcript completely. That drives me crazy. How did he just ignore that? But now I'm starting to get into what I say in my recorded. Oh, sorry, I was trying to hide this one. Yeah. Okay. So I'm going to go ahead and play the recorded video just to let you know up front, it's kind of long. It's an hour and 20 minutes. And the breakdown of what it's going to be is just like I said. We start with the actual motion, the motion for sanctions, and how weak it was, how little information was even put into it. What a fail I think it was. Then the midsection of it was case law, and I go through all of the case law. I researched every single one of them, read the entire things. I don't even want to look at my Pacer bill next quarter. But they don't match. And Blake's team has been like this the entire time. Their case law that they put up is never a match. And Wayfarer has called them on it so many times, and they still don't correct. I think they feel like they don't have to. When you can write a motion this week and it turns out this way, I mean, why bother? But then after that, I go into other cases of other judges and what they decided on how they dealt with these situations. So, like I said, it's about an hour and 20 minutes. So it is kind of long, but I hope it's interesting enough to keep your attention. And thank you so much for spending this Sunday with me. And I will come back on at the end of it to chat with you a little bit. Today we're going to talk about these ridiculous sanctions for the deposition of Today we're going to talk about these ridiculous sanctions for the deposition of Nicole Alexander. There are so many things about it that make me angry. And of course, that was the inspiration for today's thumbnail. The way that Judge Lyman took Michael Gottlieb's letter, highlighted it, and put his order on the back is one of the laziest things I've seen him do. He just completely disregarded anything and everything that Wayfarer said, in spite of the fact that they had some very good points. I want to pause it for a second because I forgot to say this part, and that just reminded me. The fact that he took Michael's letter and highlighted it and then put the order on the back, it just drives me crazy. Because that just, to me, that's just a huge signal. It's a slap in the face to Wayfarer. If you want to highlight sections of the conversation that you feel are wrong, at least do it on the transcript so you're not just being so blatant with your bias. Why are you highlighting just his and completely ignoring everything from Wayfarer? That drove me crazy. Okay, I'm going to put it back on again. None of them were addressed. It's as if he took Michael Gottlieb's letter and only Michael Gottlieb's letter and based his decision purely on that, right or wrong. We're going to go through a bunch of other cases in other courts where other judges handled things fairly. On today's episode, give me your paper. I don't want to work today. Welcome. To start this, we're going to have to do some backtracking, and none of this is really new. This began on December the 15th and was filed for the first time on December the 19th. You heard Lauren and I read from the transcript of Jamie's deposition and how wild Ezra was at that deposition. We had a good laugh, but at the time, I never imagined that anything would come of it. This is that initial letter and the demand for sanctions again. She asked for 4 things. She wants sanctions on Brian Friedman and Kevin Fritz for conduct that she claims impeded, delayed, and frustrated the fair examination of their designated expert. 2, compelling Miss Alexander to sit for an additional deposition for up to 1 hour. And 3, assigning all reasonable fees and costs to opposing counsel. 4, awarding plaintiff half of its reasonable expenses and attorney's fees incurred in connection with the deposition and this motion. And of course, it's all a big old redaction. On December 19th, this notice showed up on the docket. Now, we don't get the transcript. The final copy wouldn't even be ready yet. But when it is, I want this transcript. I want to hear how this conference was conducted, what each party had to say, what Judge Lyman asked, what he listened to, and how he responded, because this situation boils my blood. So it says that this proceeding was held before Judge Louis Lyman. It was a telephone conference that Meryl Gavernsky, Sarah Moses, and Ezra Hudson were present by telephone for Blake. Kevin Fritz and Mitchell Schuster were present by telephone for defendants. The court heard from both parties regarding the dispute during the deposition and issued its ruling resolving the dispute. The conference was transcribed through the court reporter provided by the parties. So what ruling was issued? Because the motions hadn't all been filed yet. One of the attachments with this document were excerpts from the deposition. It's useless nonsense because it's 3 pages that are almost completely redacted. But even from that, what can we see? Look at the tone. I can't help but hear Judge Lyman's words in his weak, antagonistic voice. And it looks to me like he's doing what he always does. So he invites Kevin to speak. I'd venture to say that he cuts him off once he starts. And notice what he says. What is wrong? And then another sentence. And we know it was defensive of Blake because of Kevin's answer. He says, that's right. But, so he's having to disagree with the judge who's already, before he even hears him out, he's already fighting with him. And he goes on, and you can see he interrupts again with an expert, a testifying expert, and he argues with him again. I don't think that's an objection that you would enjoy with a testifying expert. How much of the story has Kevin been able to explain here? There's only so many lines here. He's already deciding against him before he hears anything. And then Kevin starts to explain. And it looks like he gets to talk a little bit longer here. And the rest of it does look like he lets him actually speak, at least for a while. But that's all we get to see. Now, coming back to the motion for sanctions, Michael gives a long list of cases that he means to be used as case law to promote his side. Let's have a look. But before we do, let's talk about this. So that very first paragraph is basically all of the legal argument he puts in there. We're moving for sanctions. This is what we want. And this is what they did. And he has some very select cherry-picked transcript excerpts. Not much of a legal argument at all so far. His second approach is, like I said, this long list of case law, which sounds really, really impressive. So many cases listed here. Did he choose any better than they have throughout the duration of this entire lawsuit, where they've picked incompatible case law to support their claims? You be the judge. The first case is Antolini versus McCluskey, and it's a doozy. It was fought here in the Southern District of New York, and it was a hot mess. Not only for the client, but the attorney. So there's an attorney, Finkelstein. And in the course of reading this document, we see this part, that Finkelstein was arrested based upon a criminal complaint issued by the U.S. Attorney's Office for the Southern District of New York. Among other things, the criminal complaint charged Finkelstein with using the stolen identity of two individuals to file hundreds of fraudulent lawsuits pursuant to the ADA that those individuals never authorized. So we've got a winner of an attorney we're talking about here, and he was fighting this case, and this, by the way, is that judge's decision. Notice, it has a lot of parts to it. It tells the story. It tells the background. It explains everything, as an order of this kind of importance should. When you're talking about a situation that's going to cost someone a great deal of money and potentially affect their reputation, you would think that it deserves a well-thought-out and well-written court order, wouldn't you? So the background on this, the depositions were scheduled. They had a complete by date. Twice, the plaintiff just unilaterally declined to appear. Plaintiffs filed a motion to compel. Finkelstein said, no, it needs to take place by written questions, because my client cannot verbally participate. The court says, I'm not going to take your word for it. I want to have a video hearing. So the judge spoke to the plaintiff and directed plaintiff to appear. The judge concluded the plaintiff does have difficulty communicating but can answer questions. So the judge granted the motion to compel and ordered a remote live deposition. Now this is important. In the same order, the court gave directions. A court order is a serious thing, right? The court specifically said, there shall be no objections at plaintiff's deposition other than objections to form and objections on the basis of privilege, and only in the case of the latter may plaintiff decline to answer the question posed. So very clear instruction was given by court order. You must obey. This is like law. Not only that, in the next section we learned that within the first hour of the deposition, the court has to be called twice to complain about improper speaking objections, and we're going to define what that is later. Repeated instructions and coaching. Now, in the first call, the judge says, hey, I'm going to be crystal clear. I've already given you this order. You may object to the form of a question or object. State any objection you want to any question with the word objection. You are not permitted to instruct the witness not to answer except on privilege grounds or give any other instructions or speak any other words than the word objection. Very clear. The second time they've been ordered by the court. On the second call, the court stressed repeatedly that there would be financial consequences for further violation of those instructions. So now we have a court order, we have 2 times of order by phone, and we have a warning that any more you'll be sanctioned. Reiterating, I will impose sanctions for each and every speaking objection you make, Mr. Finkelstein. But it continues, coaching, leading the witness. Now, in addition to all of this is just a small portion of this. There's also some wild discovery abuse going on. But even with that and what you saw, all those clear orders, and finally a warning, when it gets time to deal with this, what does this judge say? Notwithstanding this misconduct, the court declines at this stage to impose defendant's requested sanction of dismissal of plaintiff's action. And if you notice the title, it says B at the top, the court declines to impose a terminal sanction. So terminal sanctions are when the behavior has been so bad, the judge basically terminates the case. But he says, the conduct's been bad, but I'm not going to dismiss the case. Continuing, declining to impose preclusive sanctions. Why? Because it's the well-settled preference in this circuit for courts to resolve litigation disputes on their merits rather than through a discovery sanction. And these are all quotes from the case law cited by this judge. Another case, declining to impose preclusive sanctions where less drastic sanctions would be sufficient to address the prejudice caused by plaintiff's discovery abuses. We saw how much time got wasted. 2 depositions were set up and just canceled. To chase this guy around, there was a conference to see if the guy was capable of doing this. And then lots of time wasted where they had to keep calling the court because of the misconduct. That was a lot of trouble that was added to this case. Clearing the schedule for this, arranging for a videographer, arranging for a stenographer, arranging for the attorneys to be present. And still, this judge says, plaintiff's and Finkelstein's misconduct has obstructed and prolonged proceedings in this action, but has not caused any irreversible prejudice. For example, doing things like destroying evidence. The court finds that dismissal would be incongruous and overly harsh. Accordingly, the court will not impose sanctions for closing consideration of the merits of plaintiff's claims. Now, in the case of Kevin Fritz and Brian Friedman, there was no court order. There was no instruction given by the judge. There were no warnings. Nothing. Now, the court does keep its word and impose monetary sanctions, as it said for each instance that the attorney objected beyond objecting to the form. Look at this amount, $6,250, and reasonable attorney's fees and costs. There's also an amount of $787.50 for cancellation of the court-ordered July 23rd deposition. Now that's what the court imposed for canceling a deposition. Blake canceled one. She didn't pay a dime. The Wayfarer parties had already bought tickets and were already on the plane to New York when she did it. They didn't ask for sanctions. They didn't ask for cost. But that's how cases go in other courts with other judges. The second case he mentions is Fashion Exchange LLC versus Hybrid Promotions. This is also in the Southern District of New York, and it was the year that Lyman was appointed as a judge. Now this case was something else. We can see in part 2, it says this is an exceptional case. Stands out from others because of why the unreasonable manner in which the case was litigated. There was destroyed evidence. They were non-compliant about discovery. There was a mountain of misconduct in this case. Now, this particular deposition was for a guy named Jack. They say that he was unprepared for the deposition, and plaintiff's counsel frustrated the deposition through numerous speaking objections and instructions to not answer. Now, the instructions to not answer are important, and we're going to get to all that later. And so they ask for a recovery of attorney's fees and costs, and it's granted in part, not fully. But there's a whole lot to this case, such as a warning. There had already been a warning given that depositions require advanced preparation of the witnesses because they're speaking on their knowledge of an entire organization and not just their own. So there was one deposition, very problematic. The court allows a second deposition. In addition, the plaintiff was still refusing to produce key documents regarding royalty figures. One of the things that Jack was unprepared to testify about were the tax returns. Plaintiff had not handed in these very important documents about the finances. The court said, okay, turn in your tax returns. Those had not been turned in. On the second go-round, even after being warned about being prepared, it still doesn't go well. There are still repeated speaking objections. There are prolonged debates, not just an exchange of unpleasant words, prolonged debates. It goes on and on and on and on. Because why? They say that plaintiff's counsel was testifying in, I'm going to keep calling him Jack because I'm not sure how to pronounce his name, in Jack's place. Now look at this effort that this judge puts in. By the court's count, plaintiff's counsel speaks in approximately 75% of the pages in the deposition transcript excluding redirect and simple one-sentence objections. So what does this tell you? That this judge took this sanction motion very, very seriously. She didn't just believe one side over the other. She took the deposition transcript. She did math. She sorted out how much of the time was this attorney speaking. She wanted to see, were these allegations true? She even had categories of speaking, of redirect, and one-sentence objections. There was a science to the way she observed this transcript. And she explains herself. She admits, not every improper objection warrants sanctions. Keep that in mind, because you're not going to see it on Judge Lyman's order. Sanctions are appropriate where the attorney's conduct essentially destroys a deposition, and cites case law in the Southern District of New York, cases that have said this. We now have the full deposition transcript. Was that deposition destroyed? Did Kevin and Brian destroy this whole deposition? No, they did not. This is what a judge who sits there and takes the time to look at the transcript, to study it, to do the math on it, and to look up case law to make her decision. This is what that looks like. She continues, saying that as a result of the initial improper conduct, the court ordered a second deposition. Why? Because he was unprepared to answer, and she gave him a chance to provide a more fulsome deposition. Because of the conduct that's demonstrated above, it unnecessarily extended the length of the plaintiff's first deposition and seriously disrupted defendant's ability to obtain testimony from plaintiff. These are the requirements to grant these kinds of motions. You're going to hear these words over and over again, too, because this is what regular judges consider. Not who they like more, but what does the law say? In Part 3, in the conclusion, she decides that sanctions were not warranted under Rule 37, under Code 28, Section 1927, or the court's inherent authority. But, under Rule 30d-2, this obstruction of the deposition through repeated speaking objections does warrant sanctions. Now, in this case, that was granted, but we see how extreme it was. There were warnings given. There were 2 different depositions. There was a ton of disruptions. And the fact that plaintiff's counsel spoke in 75% of the pages, that's a dead giveaway that there was too much being spoken by this counsel. We don't see that in this deposition. Now, the third case, Sintel Sterling Best Shores versus Trizetto Group. This motion's by defendants and counterclaim plaintiffs, and they ask for sanctions for alleged discovery misconduct. Their reasons are that Sintel failed to comply with the court's June 29, 2016 and October 30, 2017 discovery orders. So this is not just about a deposition. 2, they failed to preserve relevant information, including a live inventory of computer assets. And 3, they failed to search for non-custodial electronically stored information. Notice what's not here. A remark about a deposition. Why is that? Because there was a cross motion for sanctions regarding deposition conduct. So that's what that part is referred to in this order. That was about improper coaching of witnesses during depositions, and again, these speaking objections. And the claim that this happened during 2 separate depositions of 2 separate witnesses. Like the previous case, there was an order, and it said, counsel for Sintel shall refrain from making speaking objections when defending depositions. They gave very clear information. Objections as to the form of the question shall be made by opposing counsel, who shall simply state, objection. The objecting counsel shall not speak any additional words concerning the basis of the objection unless a clarification is requested. Any clarification must be stated as succinctly as possible, such as argumentative, ambiguous, or asked and answered. Notice the warning. Any violations of these guidelines may lead to the imposition of sanctions. So an order with a warning. But what happened? They continued to make improper speaking objections. For the sake of time, I'm not giving a lot of information about the whole entire motions, but they were more than just deposition problems. For example, in this case, this Mr. Moore was not adequately prepared. When you have a witness show up to a deposition and they don't have the information that they're supposed to have and that they need, it kind of makes bits of their deposition a waste of time. The deposition is to get to that information, and they should come prepared. So because of this, the court said, hey, you can have 2 additional hours of testimony. Some other things that had come up in the deposition led them to find that the discovery was really lacking. There were a lot of things that they were supposed to provide that they had not. Things that were supposed to be in the search topics that never got searched. And so in addition to these 2 hours of deposition testimony, the court reopened discovery to allow defendants to obtain additional discovery regarding the newly produced documents. Now, in the actual ruling, the judge says the earlier cross motions for sanctions, which were about the deposition, those are denied. So even though we had extensive speaking objections, coaching, that sort of thing, denied. The only thing the court granted was that extra time. And that was because the witness was not adequately prepared and much time was wasted. But in spite of the improper coaching and the speaking objections, none of that was acted upon. I'm just going to paraphrase the next one for the sake of time because there's quite a few of these. But this is in re omeprazole patent litigation. This has nothing to do with this case. When you see in re instead of so-and-so versus so-and-so, it's for special proceedings, things like probate court, for example, or bankruptcy court, any kind of special proceeding. So this case was in pretrial discovery phase, and it was resolved by a special master. And then it went on into district court. But what happened here is that an expert witness had already put forth a report to the court, already submitted. But before the deposition, for some reason, big sections of that report were deleted, just by the person who wrote the report. This was not something that was okayed through the court. It was just heavily edited. So during this deposition, counsel directs the witness not to answer any questions that were from the parts that have now been removed. You can't just reach back and remove stuff once it's already been submitted. It's been submitted to the other side. It's been submitted to the court. You can't just take it back like that and then say, oh, this witness isn't going to testify to that. The only situations that you can instruct the client not to respond is if it's privileged or if there's some agreement court ordered. But that's what happened here. There's nothing like this in Blake's case. This has nothing to do with Blake's case. So I don't know why this one is listed here. And again, makes me wonder, do these people even read the case law they put in their documents? We're going to move on to the next one, which is Morales versus Zondo Incorporated, another motion for sanctions. This one was jam-packed with discovery issues. Like most of the other ones previously, these are not just deposition issues. But then we have the conduct, and they allege that there were efforts to obstruct the disclosure of relevant information, and that it was so bad that it caused the deposition to extend to twice as long as originally contemplated, and therefore involved twice the expense. There's a long list of allegations. They claim Nelson refused to allow plaintiff's counsel access to the office telephone to call the court regarding a dispute that emerged at the deposition. So they're in there having this deposition, there's problems, you're supposed to be able to call the court if there's an issue, and they're like, no, you can't use our phone. Nothing like that happened with Blake's case. 2, they engaged in improper private conversations. You're not supposed to have these little one-on-one conversations with the client during a deposition. Some courts instruct you to not even speak at lunch to your client. They also allege that Nelson improperly coached his client to indicate how he should answer a question or to encourage him to state that he did not know the answer. 4, he directed him not to answer certain questions. Remember, that's very limited. 5, he engaged in colloquies concerning the matters on which the witness was being questioned. 6, interrupted the deposition in order to inspect extraneous exhibits and then reshuffled such exhibits to make it more difficult for plaintiff's counsel to refer to them. That sounds like a nightmare. Like, what was he doing in there? Just moving around exhibits? Putting them out of place to make it difficult? So this is not a little blow up. This is not one objection based on privilege. This is a lot of bad conduct. It's nothing like what happened in Blake's case. So why is it on here? The next case is Hire One Inc. versus TouchNet Info Systems Incorporated. I have no idea why this case is here. It's not about a motion for sanctions. It's a focus on a subpoena of a non-testifying expert. So if you look at the sentence before, he starts to say Mr. Fritz, and then it's all redacted ridiculously. So maybe there's something in that sentence that he's contending that this case could somehow be about. But a subpoena of a non-testifying expert, I don't know how that could possibly relate. So that's one big question. The next one is Nickel Industries Limited versus Salton Incorporated. This one's a mystery too. because this case was about previous contact with an expert and an attempt to disqualify that expert based on that. So I don't know if they're trying to allege something about this expert and some conversation with this expert before the deposition, but it's odd they don't ask for this expert to be eliminated, so it can't be too bad. They want to depose this expert more. But also it says here before it's redacted, even if timing were not dispositive. So the mention of that might be a clue, but with these redactions, it's all just guesswork. But anyway, this case, the magistrate did not find an issue with this witness. So whatever that's about seems completely unrelated and did not go in any kind of way towards this person. But in the standard of review, it says the standard depends on whether the issue decided by the magistrate is dispositive or non-dispositive. A district judge is authorized under 28 U.S. Code Section 636B1 to have a magistrate decide any pretrial matter except certain specified motions. These motions are ones deemed by Congress to be dispositive. The magistrate's decision does not dispose of the litigation. So piecing this together, we know that right now we do have a couple of dispositive motions under consideration. So there must be some argument about that, but with these redactions, it's hard to guess what it might be. And that takes us to Heard versus Statue Cruises LLC, where another statement is made, and most of it's redacted, so we have no idea what it's about. It also seems unrelated, but this case, if I look at published materials and docket entries for this matter, they're treating this order from May 28, 2021 as a procedural decision about interlocutory appeal and pleading standards. It's not really a discovery or deposition ruling, so I'm at a loss for this one too, but an interlocutory appeal is an appeal that challenges a non-final order issued during litigation. And that's all I can tell you for that. So the first half of these were very, very different situations with a lot of misconduct, not just a problem deposition, and the allegations in the deposition were so much worse. The misconduct was done after specific orders were given, in some cases multiple orders, and after warnings were given. Very, very different situations. The final case isn't much better. It's N-methyl tertiary butyl ether products liability litigation. And that's a mouthful. Again, these N-re cases are special proceedings, and so this one was referred to a special master. That's who oversees these, just like the previous one like this. So the issue with this deposition was that during expert discovery, a plaintiff's expert sought to use a document to refresh his recollection, but the document had not been produced, and defendants objected on work product and privilege grounds. Now, there was some conversation in this deposition about Nicole being shown a document. We'll get to that in a moment, but there was a mistake made by Blake's attorneys who thought that that had not been admitted, and they had to correct the record because they were wrong. But again, we have these redactions, so I'm not quite sure what this is about, but that's what the dispute in that case was about. Now, coming back to the third part of Michael's motion for sanctions. So remember the first one, real short, basically accusations hurled, the counsel misbehaved. Then we had this weird selection of cases that don't match Blake's case at all. And now we have this. And this, in my opinion, is the main reason why this document even exists. The second reason is I believe they're trying to get this case thrown out. Because Blake is not going to want to settle, and she's not going to want to be found wrong. But if she can find a way to make this disappear and somehow look like the victor, that would just be great for her. So honestly, a lot of the wording in these cases that they put up make me think that that's what they're aiming for, and that's why there's been this mountain of motions for sanctions, so that they can ultimately say, look at all of these things you've done wrong, this case needs thrown out. But it's not going to happen. But here's what they say now. They say this type of disruptive behavior by opposing counsel is part of an unfortunate pattern. Throughout discovery, multiple defense counsel insisted on making speaking objections, often in depositions they were not defending, and consuming time on the record to demean and orate. We're going to talk about this for a minute, making a big deal about depositions they were not defending. Now, in a deposition, there is one lead attorney that's there to ask questions, but the whole rest of the firm can show up if they want to. They can't ask questions, but any member of the defense team can make an objection. They tried to imply that that was wrong, but it's not. Now they claim that Blake's attorneys consistently asked opposing counsel to stop, including by letter. On September 29th, there we go. They made this letter back in September, in my opinion, to hold on to for a time like this. Things are looking bad for Blake. We were going into a weekend, and they wanted to make a fuss, and they wanted to get word out for PR. So they pull out this letter from 3 months ago to highlight their inappropriate and unprofessional behavior. If this situation was so bad in September, why was it never brought before the court then? And this is the end. This is the end of this motion for sanctions. Is there anything well argued about this? Is there anything proven that Wayfarer behaved badly? This is all the effort he put into this. Barely any effort at all. Wayfarer's mean. They said this. They did that. Give us sanctions. Give us more time in this deposition. There's one thing that's really missing from here, and we're going to get to that in a moment. But I want you to think about what this letter was. That's all it consisted of. What's missing? Think about that till we get to it. Now, one problem I want to say is that New York and the Second Circuit are known for being the strictest place for deposition objections. Everywhere else, there's much more leniency. So naturally, attorneys who are used to practicing in other places will find themselves at a disadvantage because there's muscle memory that takes over. Depositions are emotional. You're in there fighting. You're fighting for your client. You're fighting to protect your case. They're nerve-wracking. And so remembering the rules when they're different than how you usually operate, it's going to be difficult because a lot of the stuff you start to just do without thinking. It's not what you're used to. It reminds me, my first car was a stick. I've always loved stick. I think it's the control you get with it. It's all I had driven. And then I was driving my brother's car one day, and if you've driven a stick, you know that as you're coming to a stop, you've got to press the clutch all the way down to the floor to shift out of gear. I was just driving along. All of a sudden there was a red light, caught me off guard. My body did what it's supposed to do. My left foot went up, reached for the clutch to smash it all the way to the floor of the car. My brother, who was not wearing a seatbelt, ended up in the floor because the car just came to a screeching halt because I hadn't pressed a clutch. There was no clutch. I had pressed the brake all the way to the floor of the car. And my brain was trying to figure out what was happening. I didn't even realize what I was doing. I thought something went terribly wrong with the car, and I didn't understand what was happening. My hand was reaching out, trying to grab the stick, but my brain could not make sense of what was happening because the environment I was used to driving in was all of a sudden different. That's how we work. That's how we operate. If we have rules that we always follow, this is the way it goes, and then all of a sudden we're operating under different rules, it's difficult. It's difficult to remember, especially in certain situations. But this here is California rules. There's a lot of different reasons that you can object, and you can describe them. It's not so strict as New York. Nowhere is as strict as New York or the Second Circuit. That's known. But one of the things you can do, and this is everywhere, is that you can protect your client from harassment or improper conduct. If that's happening, if you feel that's happening, how are you supposed to object by only saying objection? Another issue is, when you object, you are preserving something that later a judge may look at and decide. If you haven't been able to explain the issue, how is the judge even going to decide that? Like, I do not understand this stance that New York has, and we're going to get into that deeper in a moment. But keep all this in mind. But I also want to remind you of the way Ezra was behaving in that little excerpt we saw from her deposition. Remember? I want my 9 minutes. This is my deposition. The hypocrisy is always so astounding to me in this case. But let's get into these rules. Now, these are the federal rules. So technically, this is all that should be concerning Judge Lemon right now. Yeah, he operates in a New York court, but it's a federal court. It's not under state rules. These are supposed to be as close to the same all the way across the board in federal court. Here's all Rule 30 says about objections. It says, an objection at the time of the examination, whether to evidence, to a party's conduct, to the officer's qualifications, to the manner of taking the deposition, notice that's in there, the manner of taking the deposition, or to any other aspect of the deposition, must be noted on the record, but the examination still proceeds. The testimony is taken subject to any objection. So I explained this to you guys before. When I talked about it, they would say objection to the form, and that it can't stop the witness from answering unless it's privileged. They still have to answer, but they are just preserving this objection. An objection must be stated concisely in a non-argumentative and non-suggestive manner. Notice there are not any rules about what words can be said and not said. It just says concisely, in a non-argumentative and non-suggestive manner. So we saw some people instructed in the Southern District of New York to what kind of objections they could make, and they were instructed that they could only say objection or object to the form, and that was it. And that's bizarre to me, because these are the rules. Concisely and non-argumentative and non-suggestive are all words that make you think you're having a conversation. You're not just stating one or two words. Object to the form, vague. If that's all you were allowed to say, you wouldn't need these words non-argumentative, non-suggestive, and concise. These words themselves lend to more words being said. You just have to keep your words a certain way. And then this rule, this is so important. A person may instruct a deponent not to answer only when necessary to preserve a privilege, to enforce a limitation ordered by the court, or to present a motion under Rule 30d-3. That's it. So, in that long list of cases, one of the biggest problems with them was that they were instructing their clients not to answer. You can't do that. But that's not the situation here. Or it's what Michael alleged, but we're going to get to that in a moment as well. This is it. As far as the federal rules on objections, this is it. In 1, it says you follow the federal rules of evidence except for Rules 103 and 615. Those are rulings on evidence and excluding witnesses. Now let's move on to the part that talks about sanctions, motions to terminate or limit. But we see there's a time limit here for 7 hours, 2 of the day, with additional time if needed. Now, when it comes to sanctions, the court may impose an appropriate sanction, including the reasonable expenses and attorney's fees incurred by any party on a person. Now, this is the language we heard multiple times, and we'll hear it more. On a person who impedes, delays, or frustrates the fair examination of the deponent. And then, here's the point where it says, if there's a bad faith deposition, or it's unreasonably annoying, embarrassing, or oppressive, counsel can even terminate the deposition or limit it. But they can even do that. That tells you depositions can get really raunchy. Now let's talk about the ABCs of depositions. What are depositions for? They are there to perpetuate or preserve testimony of witnesses. Now, perpetuate in the legal definition means to preserve testimony for later use at a trial when the evidence so gathered would be otherwise unavailable or lost. So it's preserved by a stenographer or recorded either the audio or by video. It's to obtain information, facts, to learn about other witnesses or evidence, which is also called discovery. It also serves to ascertain strengths and weaknesses of a case. So a party may bring a case to court, and their attorney may think it sounds like an amazing case. But then as they start deposing the witnesses, they suddenly find out, uh-oh, it's not so great after all. And now, before they make a fool of themselves in court, they can work towards a settlement. Or they can find out, well, this is much stronger than I thought it was, and they can ask for a big ol' settlement. Another purpose is to even out the playing field. And this is a direct quote from a case that's often cited, but it allows all parties access to the same information, thereby tending to prevent trial by surprise. Because unlike what we see on TV, you're not allowed to bring some surprise moment into the courtroom. Another thing about depositions is that they have a very broad scope. As we saw, objections don't mean much. And most depositions never see the light of day, at least not in whole. And so, because it's not a big public document, it's okay that these things are being asked, because most people won't see it. And if there is something that shouldn't make it to the public's view, it can be objected to, ruled out, and not brought to trial. And finally, they may be read or viewed during trial, and they can be used to impeach someone this way. So for example, if during the deposition somebody said, yeah, I saw him grab her, and then in court they say something completely different, they can pull out the deposition and play it or read it out and say, this witness is not reliable, they said that, now they're saying this, and they can instruct the jury not to believe this person. Sometimes people just get nervous on the stand, and they need a reminder. It can be read out. But they are a very important discovery tool. Now here's some more information on an issue I told you about earlier. We're going to compare the differences On the left, we have a decision that was made by a judge in the Northern District of Iowa. He had a lot to say. He says, many lawyers and courts for that matter assume that uttering the word form is sufficient to state a valid objection. Now, wait a minute. Didn't we see New York say that's all you can say? This is what I'm talking about. It's insane that we have such different rules. In federal court, it's supposed to have the same rules. Together, these rules provide that any objection to the form of a question must be made on the record at a deposition, or that objection is waived. So that's what I said before. You're preserving your objection. If you don't object during the deposition, you've lost your chance. You can't come back and do it later. But these rules do not endorse the notion that form is a freestanding objection. They simply describe categories of objections, like those to the form of a question, that must be noted during a deposition. Nothing about the text of Rules 30 or 32 suggest that a lawyer preserves the universe of form objections simply by objecting to form. And we just read that rule, and it certainly did not say you're limited to just these words. Now he quotes from another judge and says some contend that the objection should be limited to the words "I object to the form of the question." The rule, however, is not so restrictive. Rather, it simply provides that the objection must be stated concisely in a non-argumentative and non-suggestive manner. We just read that. The general practice in Iowa permits an objector to state in a few words the manner in which the question is defective as to form. For example, compound, vague as to time, misstates the record, etc. This process alerts the questioner to the alleged defect, and this is important here, and affords an opportunity to cure the objection. So if a judge is going to rule on this later, and it hasn't been cured or discussed, that could be a problem too. But if the person is asking in earnest, doesn't quite understand what the objection is about, how does he know how to fix it? He doesn't. And that's what these judges are saying. How can you fix it? And that the rules were never meant to be this restrictive. That he goes on, although the rules talk about objections based on the form of the question or responsiveness of the answer, this does not mean that an objection may not briefly specify the nature of the form objection. For example, compound, leading, assumes facts not in evidence. I will go further, however, and note that lawyers are required, not just permitted, to state the basis for their objections. If you only hear the word objection, how do you know what you said wrong? How do you know how to fix it? Now your deposition isn't as good as it could be because you don't know what you did wrong. In my view, objecting to form is like objecting to improper. It does no more than vaguely suggest that the objector takes issue with the question. It is not itself a ground for objection, nor does it preserve an objection. Moreover, form objections are inefficient and frustrate the goals underlying the federal rules. The rules contemplate that objections should be concise and afford the examiner the opportunity to cure the objection, and refers to the federal rules that we just read. I agree with this. I absolutely agree with this. And now on the right, we have two cases from the Southern District of New York. The first one says, speaking objections, no speaking objections shall be allowed. All objections as to relevance and admissibility shall be preserved until later ruling of the court or time of trial, months after the deposition. You're going to try to fix this now, if you can even remember what was going on. Objections as to the form of the question shall be made by any one opposing counsel who shall simply state, objection. The objecting counsel shall not speak any additional words concerning the basis of the objection unless the examining counsel requests a clarification. Any clarification as to the basis of the objection shall be stated as succinctly as possible, for example, argumentative or ambiguous. And that was decided by Judge Lewis Kaplan. The next one, this is Druckcore versus Macro Fund. All other objections to questions during an oral deposition must be limited to objection leading and objection form. These particular objections are waived if not stated as phrased above during the oral deposition. It's given Nazi. This judge is like, if you don't say it like this, you're waiving your objection. That is a serious punishment. To just take away their right for that objection because they don't say it the way you like it? It's crazy. Now, there was this case I cited earlier. This one gets cited a lot. This is the reason behind limiting what's said. It's been stated that the witness comes to the deposition to testify, not to indulge in a parody of Charles McCarthy, with lawyers coaching or bending the witness's words to mold a legally convenient record. It is the witness, not the lawyer, who is the witness. And this is the judge that made this statement. A lot of things are quoted by him in the statement that he made. But this is the point. Your attorney should not be in there being the one that's the witness. They should not be molding your words to a legally convenient record. That's what needs to be avoided. But that doesn't mean you can only say 1 or 2 words. You just have to avoid doing this. So what is a speaking objection? We keep hearing about a speaking objection. It is when an attorney involved in the deposition uses the opportunity to assert an objection to a question into an opportunity to make a speech. And this is what's at issue in Blake's case. This is what they're accusing Brian and Kevin of doing. But this is put in place to stop attorneys from coaching their witness or obstructing the deposition process. It's a limit. In my opinion, as long as you're avoiding this, I don't think individual judges have the right to make their own rules this way. You're avoiding the principle. There's a difference between an actual law and a principle. A law is don't kill someone. That's clear. But a principle is to treat people well. Well, that can be interpreted in so many ways. But it would stop you from doing anything that brings harm to somebody. This rule did not state what you can say and not say. It was a principle. So these judges that are taking it upon themselves to make laws out of this, I think they're the ones out of line. I mean, how do we have a situation like I just showed you, where in one case you're told to do something that in another federal court, you will literally be sanctioned and waive your right to object? How do we have such different demands in a system that's supposed to be unified? This is what comes of people making their own rules, something New York is famous for. So I hope that helps you understand a little bit more about what depositions are for, how they're supposed to go, what these objections are, and therefore what these accusations mean. If you still have questions, let me know in comments about that part. But now that we have that background, let's move on to Kevin's masterful response that was written with much more care, much more legal argument, much better legal argument than the motion for sanctions was. That motion for sanctions was ridiculous. It was, these guys are being bad. Here's a bunch of irrelevant case law. And let me introduce this letter from 3 months ago that has nothing to do with this, but it's going to make everybody on Wayfarer team look bad. How did that stand? I say if you were a law student and you submitted that as homework, as a motion for sanctions, it would fail. Because the biggest failing, and this is what I told you to think about and see if you could come up with it, they never mentioned how this caused Blake to suffer. They didn't say they weren't able to complete their deposition. They didn't put forth a loss. They just said, these guys are rude, sanction them. Give me another hour. What's an hour? What can you even accomplish in an hour? This is all just one big setup. And PR. She wants to get rid of this case. When you don't have a good case, this is what you do. You attack. She doesn't have anything that she can really accuse the actual defendants of. Her claims against them are so ridiculous. So what can she do? Attack counsel. Because that's all she can do. And that's all this is. And it's so discouraging that this judge entertained it. So this is the opposition, and the first thing he says in paragraph 2, she was deposed for 7 hours. One of the big things is that the deposition has to have been destroyed by the conduct, that you weren't able to get the information from the witness that you needed. He's saying she had a full 7 hours. She had her deposition, and that's what he spells out in paragraph 3, that the rules say in order to get sanctions, it has to impede, delay, or frustrate the fair examination. The full deposition was done. It was not delayed. The few little issues that are in this deposition that we now have the entire deposition of, their fair examination was not taken from them. There were a few unpleasant words exchanged from both sides, but it did not come to this, impeding, delaying, and frustrating the fair examination. And then he says, one of Blake's counsel's tricks, cherry pick the few pages of the deposition. As he says, a mere 10%, presumably to create a false narrative. We submit the entire transcript so that the court can see that Miss Alexander's deposition was not impeded, delayed, or frustrated. And here's the thing. This judge doesn't mention anything about this transcript. I bet he didn't even read it. In all these other cases, the judges quote, they did the math. They give timestamps in the deposition of things that were said. They choose sections of the deposition to put in their order that's many, many pages long. I don't think he read this. Kevin says upon reviewing the transcript, the court will see that the Wayfarer party's counsel concisely and appropriately objected to the form of certain questions, did not utilize speaking objections, and permitted Miss Alexander to answer every question except for one topic, which is addressed below. And then we get to the footnote. He said Miss Alexander's deposition had nothing to do with Miss Lively's sexual or romantic history. Nonetheless, the motion attaches a self-serving letter from 3 months ago sent by Miss Lively's counsel to the Wayfarer party's counsel, complaining erroneously about certain deposition questions purportedly concerning her sexual or romantic history. That's that letter. That's what it said. It even brought up the rape shield law. It was so inflammatory. And the thing about it is, it was just a letter written by them. That's not proof of anything. Where was the transcript to prove the allegations that were made in that letter? That letter is not proof of anything on its own. The questions at issue therein pertain to Miss Lively's reputation, which she put at issue. He's saying that the questions we asked were not sexual romantic history. They were about her reputation. This is the issue. And they did this to make it sound like they're creeps. And then he says, given that Miss Lively did not seek relief from the court months ago about any purportedly improper lines of questioning, why didn't you? Blake, Ezra, Michael, and is not seeking such relief now. Why are you bringing it up if you're not seeking relief? The motion seemingly was filed solely to generate inflammatory headlines and falsely besmirch the character of the Wayfarer party's counsel. And that is exactly what it did. And it posts a couple of different stories that came out right away that I'm sure Leslie Sloan ran to these places with that information so that they could get it wrong with no proof. Now think about times that Blake's attorneys have put things like this, articles that were put out there, and the kind of nasty response that Lyman had towards Wayfarer, scathing remarks, publicly dressing them down. He does not even address this in his order. How many times has he admonished Wayfarer for articles that are out there in the public? And then you've got this, where the accusation is not even true. Look at this title. Questions about her sex history should be off limits. Blake Lively's lawyers blast Justin Baldoni's team over probing her sex life in disruptive depositions. And he doesn't see fit to mention this at all. He doesn't try to get to the bottom of it. He doesn't mention it. Did he even read this letter? I have doubts he read the transcript. Now I have doubts he even read this letter. He doesn't say a word about it. He continues, this motion does not identify any material area of testimony Ms. Gavernsky sought to explore that she was prevented from exploring by counsel's objections. And he cites case law that that's required. So as I said earlier, how did this alleged conduct harm Blake's deposition? And Michael's so lazy at this because he knows he's going to get what he wants that he didn't even legally support this motion for sanctions. Legally supporting it would have been this, telling the court how this conduct caused her not to be able to explore what she needed. And guess what the rest of the courts in Southern District of New York say? They deny sanctions motions where objections to deposition questions, while numerous, were not inappropriate or unwarranted, where the vast majority of the objections were not speaking objections, and where defense counsel only instructed the witness not to answer one time. This is the situation of this deposition, not those others that Michael listed that had mountains of issues. This is what we're facing. And this is what the Southern District of New York says. They deny it. What else do they deny? Sanctions motions where deposition transcripts reveal that any speaking objections occurred were not so pervasive or disruptive as to warrant sanctions. A review of what Blake labels frequent speaking objections demonstrates the triviality of the motion. Later I'm going to record the deposition, but these are some main points from it. So Team Blake alleges that they interrupted the deposition to ask whether she could review an exhibit. But even their own examples show that it was Blake's counsel, Meryl Gavernsky, that made the mistake. She was completely unaware. She was the one that was not prepared. How about sanction her for not being prepared? She was unaware that Miss Alexander had amended her expert report. Then, that's not all, she erroneously claimed that the amended report had not been served upon her. It had been. Not only had it had been done a month earlier. How are they going to say this to her by just being allowed to say object to the form? So they professionally steered her in the right direction. They put the timestamp here so that the judge can read it. The next thing, Miss Alexander, who had never previously been deposed in any litigation, let alone remotely, was advised to download an exhibit so she can review the entire document as one would do in person, rather than review only the portions viewable to her through Miss Gavrnsky's screen sharing. So here's the situation. There's a document. This woman is having her first deposition. Now, I know for myself, and I've told you this a million times, I print stuff because I can just comprehend better on paper than I can on a screen. But here she is, probably nervous as can be, doing her first deposition. And Meryl's going, look at my screen share here on this little bitty screen. What I choose to show you, you can look at that. And her counsel says, hey, let's download it so you can look at the entire thing. Because if we were in person, we would hand it to you and you would have it. Right? What's wrong with that? C. Miss Gavrnsky asked Miss Alexander to summarize a lengthy article cited in the expert report. The witness was confused about whether she was being told to summarize it offhand from memory, and the Wayfarer party's counsel asked for clarity. Oh my goodness, sanction those beasts. What happened? Miss Gavrnsky launched into a tirade instead of clarifying what she was asking Miss Alexander to do. Why doesn't the judge address this? Did he even read this? And like I said, later I'm going to go through and make a recording of how all this happened. But these are the situations that Blake said, these are why we need sanctions. Have any of these been bad? Have any of these been deserving of punishment? Or are they reasonable actions? During one exchange cited by the motion, Miss Gavrnsky interrupted the witness who was confused by the line of questioning, and the Wayfarer party's counsel suggested that Miss Gavrnsky listen to the witness so that the questions could be clarified. So she's trying to talk, she keeps being interrupted, being confused by the interruptions, and they tell Miss Gavrnsky, let her finish talking. How many times have you heard that in a deposition? Over and over and over again. That's a very common thing to be said at depositions. These are the things that are redacted in her ridiculous motion, and this is all they were. Now there's more case law denying sanctions because there was no indication that request for clarification of deposition question was made in bad faith or frustrated the deposing party's ability to conduct a fair examination. Remember, that's what the rule says. This didn't impede or deny her a fair examination. For them to say, listen to her, let her finish speaking, because you're confusing her. Even if such colloquy can be liberally construed to violate Rule 30c2, which it should not, violation of the rule is mitigated to some degree if the colloquy that occurred as a result of objections related to matters of clarification. There's the case law right there. Southern District of New York in 2020. When you're asking for clarification, it mitigates this violation. A witness cannot answer correctly if they don't understand the question. Here's another one. Denying sanctions motion, even though defense counsel spoke more than was necessary to state his objections under Rule 30c2. Notably, at the start of the deposition, Ms. Gavrnsky failed to instruct the witness, as is standard in depositions, that if she did not understand a question, she should say so, and Ms. Gavrnsky would rephrase it. This case, again, that I told you gets cited from a lot. It says, at the beginning of the deposition, the deposing lawyer should explain to the witness, as did Mr. Stewart here, that the witness should feel free to ask for clarification at any time during the deposition. And this should be done whether it's your first deposition or your 50th deposition. In this case, it was her first, and she failed to instruct her at the very beginning what to do if she misunderstood. That's on her. If Gavrnsky wasn't going to do it, somebody had to do it. Instruction to answer if you understood or if you can were not improper. Also found in this Wang case. Continuing, those phrases show defense counsel reminding the deponent that she should answer the question notwithstanding the fact that he objected. And then he says, examples of improper speaking objections are those made by Miss Lively's counsel, Ezra Hudson, at the deposition of non-party Jenny Slate. And he includes it. And of course it's sealed, because Jenny Slate's a celebrity, and in Lyman's court, there's celebrity privilege. Everybody else has to bear everything, even stuff that other judges might consider to be privileged. It all gets exposed here, but if you're a celebrity, you have celebrity privilege. I mean, at this point, it needs to be added on as individual practices. Celebrity privilege. If you're famous, you don't have to show anything, and I'll give you months to keep it concealed. Another way Gavrnsky failed is she never instructed Miss Alexander that she could request a break, and that's routine. Miss Lively nevertheless inexplicably takes issue with the suggestion after 2 hours of questioning that Miss Alexander and the stenographer be provided with a break during the deposition. Remember Ezra screaming, I'm taking a break, we're taking a break, after 1 hour? After such break was requested by Miss Alexander's counsel, Ms. Gavrnsky proceeded to ask another question, then utilized the guise of a pending question as a basis to refuse a break, and ultimately was proven wrong when the stenographer confirmed that no question had been pending. Did Judge Lyman mention any of this? Did he even read the deposition about Ezra? Did he read this transcript about this? He sure doesn't mention any of it, does he? And then he says in sum, the questioning went relatively smoothly, especially after the parties' counsel conferenced with the court during a break, and Miss Lively failed to show that the deposition was impeded, delayed, or frustrated in any substantive manner, and her motion for sanctions is required to prove those things, and it didn't. And there's case law for that too, denying sanctions motion despite what? A heated exchange at the end of the deposition, because any conduct that violated Rule 30 was not extreme and had no material effect on the testimony. Yes, angry words were exchanged by both sides, but it didn't meet the standard. The only time Miss Alexander was instructed not to answer was based on privilege and work product and in connection with questions concerning her conversations with separate counsel. Rule 26b-4c protects from disclosure counsel's communications with testifying experts. Communications between a party's attorney and an expert witness retained or specially employed are protected from disclosure except for communications that, among other things, identify facts or data that the party's attorney provided and that the expert considered informing the opinions to be expressed. He's saying this was privileged. This is the only time I said you can't answer, and this was why. In response, Ms. Gavrnsky improperly attempted to debate counsel during the deposition about the instruction to Ms. Alexander not to answer. Is this bad conduct mentioned? No, it's not. Did he even read it? I don't know. In violation of Rule 4c of this court's individual practices, so against Lyman's own rules, Miss Lively's counsel failed to meet and confer after the deposition or even during a break therein concerning the propriety of the objection. Of course not, because they wanted to take it straight to a motion for sanctions. So all of these rules are broken, including Lyman's own. He says the motion should be denied for that reason alone. The procedure was wrong. You don't jump straight to a motion for sanctions. You have to do this first. And he quotes Jones versus Abel for this, Lyman's own rulings. Had Miss Lively's counsel adhered to the court's individual practices concerning the resolution of discovery disputes, we would have agreed to a short continuation of Miss Alexander's deposition via remote means and on a mutually convenient date, limited to questions concerning her communications with a separate counsel, identifying facts or data that such counsel provided to her and that she considered informing her opinions expressed in her report. We so stipulate now. So all of this could have been avoided, judicial economy served, if they had done this correctly, but they didn't. And do they get punished for it? No. Would Wayfarer have? Yes, because we know that because they have when they didn't follow the rules in a way that Lyman liked. But this doesn't even get mentioned by him. The motion to sanction Brian Friedman and the undersigned is frivolous because it's based upon an alleged ongoing pattern of deposition misconduct, but cites no prior conduct by either attorney at any deposition. You can't just... You're not supposed to just make these statements and not support them. Will Judge Lyman care? Nope. He'll just take Michael's word for it again. And now these are the cases that I read to you about that Michael quoted. He's saying, furthermore, the motion cites cases in which the attorney deliberately violated repeated orders of the court, engaged in prolonged and unnecessary argument regarding the relevancy of a simple question, and instructed the witness not to answer on relevancy grounds, or was held responsible for its client's violation of orders to produce documents. I showed you all of those cases, none of which Miss Lively even alleges or demonstrates that either Mr. Friedman or the undersigned did. These cases are not similar at all. The conduct is not equal at all. And then he says, the only ongoing pattern is Miss Lively's use of the media to disparage others and distract the public from the legal issues at hand. And then the footnotes. There's some amazing footnotes in here. Ironically, it was Miss Gavrnsky's own improper attempt to debate counsel during the deposition that prompted Brian Friedman's request to her that she cease such misconduct. So she was the one acting improper. He calls her out, and then he calls out this Jamie Heath deposition transcript, saying it's an entirely different situation where counsel was not responding to any pending question, but raising concerns about lengthy breaks that Miss Lively's counsel was taking. This was an issue that they brought before the court. It's on the record. And it wasn't Kevin Fritz or Brian Friedman. Why was it even there? I'm glad it was there. It was entertaining and it showed what a kook Ezra is. In my opinion, don't subpoena me again, Ezra with an S. And now we get to the inspiration of the thumbnail. This chaps my hide time after time after time. This laziness. I went through all of those cases when I prepared this video. All of those judges were seriously evaluating the situation. Their answers were pages and pages of legal standard, background of the case law, quotations, and timestamps from the transcripts. They ranged from 20 and even 49 pages long. They gave fair decisions backed up by the authority behind them. This man takes his favorite, Michael Gottlieb's paper. How many times have I talked about how he always takes Michael's filings and follows them as if the other side's documents mean nothing? It's even been to the point where he's had to undo a ruling because he took Michael's word and it was wrong. He went against his own ruling previously and against his own words on a hearing that we all heard. Because he went by what Michael said in his filing and nothing else. He didn't go by Wayfarer's defense. He didn't go by his own words, and he ended up making a fool of himself. But he still does it. He just takes whatever Michael says and says, okay, this is it. This is the truth. And disregards whatever argument Wayfarer makes to defend themselves. This time is the laziest of all. He can't even write a proper order on something so important that's going to cost these people probably over $10,000 easily. It's going to cost the court. It's going to take time away from everyone. And this is all he's willing to do for it. He pulls out a highlighter and highlights Michael's document and only Michael's document, as if nothing Wayfarer wrote matters. And he goes through and proceeds to highlight points from this. Have you ever seen such a thing? This isn't about rearranging the schedule, which often gets its very own order. This is a motion for sanctions. This is going to disrupt a lot of people, including a third party that he supposedly cares so much about. But she's not a celebrity, and this is what he based it on. And one of the things he highlighted was her illness. Now, it wasn't anything major, but that's not the point. And in his letter to the judge, he mentions redacting it. He files a motion to seal so that that doesn't get shown because it is her health. It's not our business. Does he care? No, he highlights it. She's a third party, Lewis. You said you protect third parties. Oh, that's right. It's celebrity privilege, and she's not a celebrity. And then, on the back of it, he puts these two paragraphs. And this is all he says. The motion for sanction is denied except to the following extent. Mr. Friedman is admonished for his conduct and comments during the deposition, which are reflected in their entirety above, and warned that future such conduct may be met with sanctions. So Brian gets the warning, Kevin doesn't get a warning, everything is granted, except he's not personally sanctioned. So he took nothing into consideration that Wayfarer said, only Michael's words. And 2, by agreement of the parties, counsel for Lively shall be permitted to take an additional remote deposition of 1 hour of Miss Alexander limited to questions regarding her communications with separate counsel. So she has to talk about that, her communications with counsel that should be privileged. But no, we've got to drag everyone back out and do another deposition for an hour. And then he gives one case that says a successful deposition process requires parties, attorneys, and witnesses participating in depositions to conduct themselves with civility and decency. Counsel are expected to cooperate with each other, consistent with the interests of their clients in all phases of the discovery process, and to be courteous in their dealings with each other. He has seen really nasty things exchanged between these people. What happened in this deposition was no worse or different. It was no worse or no different than what Ezra said or did in depositions. No worse or no different than what Gavrnsky said or did in depositions. This is insanity. Only Brian out of everybody gets this warning. To the extent that the witness invokes the privilege, counsel may inquire into and test the basis for that assertion of privilege, and counsel shall be permitted to inquire into the matters expected from attorney work product protection by Federal Rules of Civil Procedure 26B 4C. But you can't do that during a deposition. So Kevin was not wrong to tell her not to talk about it then. and later it could be hashed out if it's not really privileged. But not during a deposition. Because counsel for the Wayfarer parties improperly invoked attorney-client privilege, the Wayfarer parties shall pay the cost of the court reporter and videographer for no more than 1 hour, as well as the reasonable attorney fees for 1 hour for one lawyer for lively. So he lazily highlighted Michael's interpretation of events, admonishes Wayfarer, and not a single word about the conduct that Wayfarer reported about Blake's team. Now, I don't want to hear any excuse that it's because Wayfarer didn't file for sanctions. They put these accusations to the judge. They don't have to ask for sanctions. Is that just my opinion? Let's look at case law in the Southern District of New York. Let's see how better judges make better decisions than Lazy Lewis. In Dolaretha Edwards versus Robert Wilkie, this judge did a thorough review of the deposition transcript. She acknowledged both sides' conduct, things like objecting, colloquy. She acknowledged that those occurred. She also considered context when deciding sanctions were not warranted. So in this case, there was a request to reopen discovery for some other issues, and she also asked for sanctions for alleged conduct at the depositions of 2 of the witnesses. So this judge gives the whole relevant procedural history and background. That there had been several extensions already, the scheduling order had been amended, setting a new fact and expert discovery deadline, plaintiff filed a letter requesting an additional 60 days, defendant opposed, there were 2 more letters, and so it was reassigned to this judge. There was a new deadline that came and went. There was a request again to reopen discovery. The schedule gets changed again. The depositions are completed. Immediately, she claims that she was denied a fair examination in these depositions. She says because of the sheer volume alone of the objections, and she alleges that defense counsel's coaching and other allegedly disrespectful and disruptive conduct, including one instance of consultation on an illusory form of privilege during a pending question during the Walls deposition. This judge says she finds that no sanctions, whether monetary or otherwise, are warranted. This plaintiff is actually asking not for money, but to reopen discovery. She's been trying to do this and failing. So she has an agenda, very much like Blake. This judge sees through it. Now, in her proper order, that's 13 pages long, we saw she just went through all the background. Now she gets into the legal standard to explain her decision. This quote in blue, this is a citing from Wright and Miller. This is a big old set of books that's used for legal research. It's often quoted by judges to explain procedural rules or to interpret history. It clears up ambiguous rules. And where there's no controlling precedent, it can help to summarize the state of the law. So she notes that. And it says it is noteworthy that the rule stops short of absolutely forbidding any objections whatsoever, except those that would be waived unless raised. So here is an interpretation given on these rules. It also quotes from Federal Rule 32D-3B, timely and contemporaneous objections necessary for objections to form and relating to matters that might have been corrected at that time. Well, if that's in the rule, correcting something at that time, doesn't that tell you there should be some conversation there? If you just say object to the form, how are you going to correct anything at that time? So these rules are not implying what New York has translated them to imply. She also cites case law that although not every improper objection warrants sanctions, sanctions are appropriate where the attorney's conduct essentially destroys a deposition. This deposition was not destroyed. It was a 7-hour deposition. He only provided an hour for those questions that Kevin said were privileged. So that tells you that she got what she needed from that deposition. It wasn't destroyed. It was successful. It doesn't meet the standard. She continues, citing more cases, all from the Southern District of New York and the Second Circuit. An award of sanctions under 28 Section 1927 differs from an award under Rule 30D-2, however, because sanctions under Section 1927 require a clear showing of bad faith, when the attorney's actions are so completely without merit as to require the conclusion that they must have been taken for some improper purpose, such as delay. Do we have that in Blake's case? No. Now, this plaintiff also argued that frequent objections were not for proper purpose, but rather as a means to coach their witness and to frustrate the flow of deposition. They aren't even accused of that in Blake's case. The allegation is that they objected too frequently, engaged in colloquies, intended to coach the witness. They assert that they raised objections approximately 80% of the time, making objections or speaking at least 531 times. Notice what this judge does that Lyman should have done. Plaintiff asserts without citing to any case law that the sheer volume alone, without looking at the context, should warrant the imposition of sanctions. Why didn't he call out the fact that her motion was not legally supported? That list of case law did not support the arguments. She did not present to the court how her deposition was destroyed, and he says nothing about it. She recognizes that context is important because counsel defending a deposition have an obligation to make timely and contemporaneous objections under Rule 32. We just saw that rule that said that. And now she quotes binding authority from the appellate court of the Second Circuit. And I have the quote from this case, Cordero, that quoted from Phillips, and this is directly from the appellate court. Courts in the Second Circuit have declined to impose sanctions based solely on voluminous, unwarranted, and argumentative objections where opposing counsel was not prevented from completing the deposition, declining to issue sanctions even when the attorney's conduct clearly hampered the free flow of the deposition and was inappropriate and at times even obnoxious. Those are not good enough grounds. So says binding authority of the Second Circuit. Now, we know she did her job because it says the court has reviewed the transcripts of Ms. Jackson's and Mr. Wall's depositions. She read 2. I don't think Lewis even read the 1. He doesn't signal to any of them. He doesn't quote from any of them. He doesn't give timestamps of any of them. He just lazily highlighted what Michael wanted him to consider. But she says, the objections, while numerous, were not inappropriate or unwarranted. And they only instructed Mr. Walls not to answer 1 time, which is exactly the situation with Blake, about something they considered privileged. And then she says, very importantly, most importantly, plaintiff was able to complete both depositions and, here's the key, has not identified any material areas she sought to explore that she was prevented from exploring by defense counsel's objections. Even the most contentious areas in each witness's depositions, referenced and discussed by both plaintiff and defendant in their briefs, do not rise to the level of sanctionable conduct. That's a proper ruling. She put forth the effort. She did her research. Look at the footnote, bottom left. Upon a further review of the deposition and plaintiff's memorandum of law, the word objection appears on 133 out of 167 pages of Miss Jackson's transcript, or on 79.6% of the pages. It is not the case that defense counsel spent almost 80% of the time of the deposition making objections. She actually did the math. All Judge Lyman could do was highlight. Now, when Lauren and I acted out the transcript of Ezra at Jamie's deposition, we had a good laugh. We made our remarks about how she behaved. Her behavior wasn't stellar, but never would it have crossed my mind if I just read that to say, sanction her. As I said earlier, depositions are an emotional time. Everyone's keyed up. Attorneys are protecting their client. There's a lot at stake. We're human. Emotions get the better of people. Even Ezra, I wouldn't say, oh, sanction that conduct. It is ridiculous that they filed for sanctions, and even more ridiculous that Lewis entertained it. The next case, Sanders versus New York City Department of Education. This one's in the Eastern District of New York. Having considered all the submissions on the motion, not just one, the court denies the second motion to compel Rule 30b-6 witness and for sanctions. So what's going on with this case? We have some similarities. The witness asked to see a document to refresh her memory. We have the issue about the document that Gavrnsky erroneously thought she didn't have and objected about another document being downloaded for the witness. But this judge says Rule 30b-6 is not designed to be a memory contest. Presenting a witness with relevant documents so they can answer fully renders the deposition passable. Now, in this case, the plaintiff was asking for a deposition with an additional witness. The court says this is unnecessary because only 4 questions that covered narrow topics were unanswered. What does that sound like? The few questions that Kevin said, these are privileged, do not answer. The court has now said they're not privileged, you must answer, but it's a very similar situation. So what does this judge do? Instead, on or before November 30th, 2022, defendants will serve an affidavit by a person with sufficient knowledge on behalf of the corporate defendant that answers the 4 unanswered questions quoted in footnotes 1 and 2 below. They didn't call them back to do a whole nother deposition for a couple of questions. They said put it in an affidavit. Judicial economy. They also continue when determining whether sanctions should be imposed. Courts in the Second Circuit weigh the following non-exhaustive factors. 1, the willfulness of the non-compliant party or the reason for non-compliance. He said he felt it was privileged. 2, the efficacy of lesser sanctions. Could it be put in an affidavit? 3, the duration of the period of noncompliance. And 4, whether the noncompliant party had been warned of the consequences of noncompliance. There had been no warnings. This letter they bring up now for dramatic effect was never brought before the court. They never asked the court to issue a warning. Nothing. The judge also explained that they didn't see any bad faith or prejudice and ruled that plaintiff is not entitled to sanctions as to defendant's counsel's deposition objections. Why? They quote that same rule we've heard a million times now, only when a person impedes, delays, or frustrates the fair examination of the deponent. Defendant's counsel made frequent objections. The questions were nonetheless answered. This one also quotes from Cordero that courts in the Second Circuit have declined to impose sanctions based solely on voluminous, unwarranted, and argumentative objections where opposing counsel was not prevented from completing the deposition. This judge also noted the failings of the other side, saying that the questions posed often lacked sufficient clarity and specificity. Gavronsky was a mess. Why didn't he mention that? Why didn't he mention there were times that clarity was needed? There was no material frustration or delay in the deposition where counsel instructed the witness not to answer improperly, but the witness did answer regardless. They talk about how it's permitted under attorney-client privilege grounds, and then the others had to do with Disabilities Acts and other things like that. And the final one, this one didn't go to an actual motion for sanctions. This was a letter requesting a conference about deposition issues. Remember the whole meet and confer and meet with the court first? These people did what they were supposed to do. This judge said, no thank you. She said no conference is necessary. This is a colleague of Lewis. No sanctions will be assessed at this time. She's like, I'm not even going to consider it. Although plaintiff's counsel made several improper speaking objections, defendant's counsel compounded the delay by engaging in extended colloquy over the propriety of the objections. Is that not exactly what happened here with Gavronsky and Ezra? She's basically saying, yeah, there were several improper speaking objections, but you weren't innocent either. You engaged and delayed things yourself by fighting. So no, we're not even going to think about sanctions. Isn't this what Lewis should have done? Hey, I understand what they said here was argumentative, but, the transcripts of you are just as bad, so we're going to call this even and employ some judicial economy, not causing a whole nother deposition, send an affidavit for the questions that weren't answered about conversations with an attorney, and save the court a lot of time and money and everybody else time and money. I mean, this millionaire doesn't seem concerned about the cost this case has brought to the court. So instead of entertaining sanctions, she says, hey, during any future depositions in this action, and then she gives them a list of things that they should follow. She's like, you both messed up. You both said stuff you shouldn't have said. Don't do it again. But we're not entertaining sanctions. It is neither necessary nor appropriate for the objecting attorney to argue the point further by stating, for example, you are putting words in his mouth. Hypothetically, you are testifying for him. And there's the timestamp. She read the deposition. She marked the timestamp to know that the other side wasn't innocent either, and so they weren't getting anything. This is what he should have done. So next time, Lewis, go ask your colleague, Miss Barbara Moses here, how to be fair and impartial, since you don't seem to know how. So, did you see the difference between the way he handled this motion and the way these other judges did? I mean, is it just me? Or did you not notice they spent pages? The longest one of all of the ones that I read was 49 pages. This guy highlighted Michael's letter and put 2 paragraphs on the back of it. While the rest of them, they wrote the whole background. I mean, this was a motion for sanctions. This is about money. This is about reputation. And if he harms Wayfarer's attorney's reputation, he harms Wayfarer's reputation. And that's what I think he doesn't take into consideration. Because he doesn't care, in my opinion. But the pages, the research, these judges actually read the transcripts. They brought up stuff that wasn't even mentioned in the documents, stuff that they found. And a couple of them noted the conduct of the opposing side. You don't have to have a motion for sanctions to address a situation that's been presented to you as a judge. Kevin's letter mentioned all kinds of situations where Blake's team have been wrong as well. He included transcripts for the judge to look at. You don't have to ask for sanctions. He brought this to his attention, and not one word was said about it. They did the research. They put the timestamps. They found the stuff they wanted to talk about. They addressed the mistakes on both sides, and they supported their decisions with legal standards. He didn't do any of that. This wasn't something simple like changing the schedule. And it didn't even get its own independent document. It got put on Michael's document. And it's disrespectful. These people are fighting for their client. They're fighting hard. It's a David and Goliath situation. Kevin wrote a beautiful masterpiece of a document to oppose this motion. Had, like I said, those exhibits with it, the transcripts with it, and not one word. And you can try to excuse it by saying, well, they didn't file for sanctions. No, that's not good enough. You just saw what those other judges did. They did their job. Getting warnings like this is bad for an attorney's reputation. And it's bad for your client. Because the way they run to the media about absolutely everything, and it gets put out there. It's so wrong. He is supposed to be neutral. But his actions and his attitude do not signal neutrality to me. And after seeing all these other judges and how they approach the situation, I can see, because sometimes I'm like, maybe it's me. Maybe I just have too high of a standard. Maybe I'm just being too critical. Maybe I'm going too far. And then I saw his colleagues and the way they dealt with it. And I was like, no, it's not just me. This is not how the rest of the judges are handling these exact situations. And it's very concerning. We are very close to trial. And this man is going to be the one sitting there in this robe addressing these attorneys and sustaining or overruling their objections in front of the jury. He's going to decide what information gets to be put in as evidence. And it's frightening. It's frightening. Because for those of us who demand justice, true justice, fair justice, and we don't care if someone's a celebrity or not, they don't deserve more justice. Why is Jenny Slate's deposition marked as confidential? Why? Because she's a celebrity? There is no reason this woman's deposition should be confidential. What is so special about her? But everyone else just they don't get protected. Only the celebrities get protected in this case. I don't know. What do you guys think? Could you see the difference between his order and these judges' orders? I mean, it's so apparent to me. Yes, that's my worry. I want my 9 minutes. I thought that was an L, and I was trying to figure out what it said. That's hilarious. I'm worried he won't allow Wayfarer party's evidence in the trial. He has control of what makes it to trial. He will ruin it for Wayfarer party. I'm afraid of that too. Yeah, Lena says we are angry. We are angry. We expect justice. Lori says I feel hopeless, so I can only imagine how Wayfarer feels. Agreed. That's what I think, Rose, is it's confidential because it didn't back up Blake's side in a lot of areas. So I meant to look this up, but then the case has just been nonstop. I mean, we finally have a moment to breathe, but as of tomorrow, they're going to have to submit the letters to keep things sealed. So that's going to start up again. But um, I wanted to look into that because that was a rumor going around, and I actually had repeated it on a live before I looked it up, and I had to make a statement saying, "No, this is incorrect." There Gottlieb is like Smith in New York. It's everywhere. And there is another Michael Gottlieb, and it's not him that has all the lawsuits. Now he was in the Drake lawsuit, and I feel like there might be one more, but it's been a while since I looked at that, so I'm not sure. But I just wonder like what other groups they might be in. But I did find out his wife is also from where Lyman's wife and at least one of his daughters went to college. They're from the same college with Sean Levy's daughter, the one that Blake spoke at. So him saying he didn't know who she was is kind of strange because he was there and his wife made a big donation, is what the rumor is. So, yeah, I don't know, but I worry the most about connections because connections can be a very scary thing. Oh, it's Diane. Okay. Hey, Diane. I love the new name. Yeah, I do too. Because I don't have time to do all the things that I want to do. I haven't even been able to keep up with all of the filings. I mean, this one was filed on the 19th, and I'm just now getting to it. But yeah, I would love to see some deep dives into the relationships of these people. So I'm kind of working on one with his brother right now. But let's see. Gloria says there's a scene on the TV show Cobra Kai where one of the karate teachers that's with the corrupt karate dojo says, "Don't worry, this judge is in our pocket," when they're at competition. But yeah, I don't want to say too much on that, but none of this makes sense. No, there's really nothing we can do. He's a federal judge. Like I said on my live with Lauren and Omar the other day, in the history of federal judges, because they're appointed by the president and it's a lifetime appointment. They're not like other judges that get temporary terms and they can be let go. Like these guys are in there for life. It takes the Senate, the House of Representatives to even impeach these guys. And of the 15 guys that have been impeached, only 8 were actually removed. And it was really bad stuff, like mafia type stuff. So there's it's hopeless. And I hate to say that because I hate hopeless situations. But this guy, in the first 2 years of him being a judge, it was reported in the Wall Street Journal that he had not recused himself 13 times when he should have. He's had cases overturned because he didn't recuse himself. He owned stock in a company and then presided over a case with them. And that had to be redone. The whole trial had to be redone. And still he sits there. And that was back in 2022. I mean, who knows what's been done since then? Yes, that's what I'm worried about. Gloria says, I feel the judge is going to constantly overrule any objections Wayfarer makes and sustain any objections Blake Lively's team makes. Exactly. He can strike things from the record. He can do all kinds of things. Christy says, I don't think the judge is reading the majority of the filings. Well, I think he reads all of Michael's, so say that much. Coach Isabel says, I believe this is worth an appeal more and more as time goes on. I'm convinced that Pandora's box is open and something major is bound to happen now. They are a mocking stock. I have a lot of confidence in Shapiro because, like I said earlier in the chat, she has actually gone before the US Supreme Court 3 times, and that's huge. Most attorneys never get there, not even one time. But of the 3 times she's been there, she won twice. And even the ones she didn't win, there was something about the case that changed law. So she's good. I mean, that is a humongous accomplishment. She knows how to find this stuff and she knows how to fight for it. So I have a lot of faith in whatever she decides to do about the situation. So that's the one thing that's given me hope right now is Shapiro. Yes. I'm doing research right now about his brother and about Hollywood, and there's some really interesting financial stuff going on there. Yeah, like Gloria says, none of us can do anything. It has to be done by Justin's team to make a complaint before the judicial board, and that's true. And if we get involved and start doing stuff like that, it might make things worse. It might make him more angry. We don't know if he's the kind of person that reacts to that kind of stuff and sets in even harder. So when it comes to that kind of stuff, I think we just kind of need to let Wayfarer decide what they want to do. However they want to handle it, they know what to do. Yeah, that's a good question, Eliza. Eliza, when are other federal judges going to worry about Lyman's dealings with this case? Roses said he did just have the Drake and UMG case against Kendrick. Ashka says, I'm sick of Lyman being lazy and not reading anything except Michael Gottlieb stuff, of course. It really does look like that's what happened this time. Glory says, and Blake Lively has done speaking engagements at that college. Yes, and from what's being said, his family was in attendance when she did, at least one of them. And his wife made a big contribution. So, yeah. You must have a connection with judge to have a fair trial. That was the way of the old times, and it still exists. It still exists. That's the reason my YouTube channel started, because I started speaking about how that was in existence in South Carolina. That was the part of the Murdaugh case that I went after. It wasn't about the murder. It wasn't about the boat crash for me. It was about the corruption there. It does still exist to our day. There's situations being looked at. That's another on one of my big research projects is some of the stuff that's going on in the Southern District of New York. What do we write to Lyman about this time? We don't. We let Wayfarer handle it. I mean, I don't think any of us can compare to what Shapiro can do. Same here, Diane. I can't wait to see what garbage excuse they make to keep everything sealed. I don't think he will enforce his own rules being transparent to the people. No, because he's going to protect the celebrities. He's already shown us that. The rest of the third parties, their stuff will get exposed. Even conversations with attorneys, even conversations with your dad, none of that stuff does he protect. But when it's a celebrity, oh yeah, they can keep their entire deposition sealed. It's insanity. But yeah, I can't wait to see And that's due tomorrow. I cannot wait to see what she says as an excuse. Roses Wild says, Cass, did you know that Doug Lyman did a documentary on sexual harassment in the workplace of famous people in 2023? I did not know that. Where can I see this? I'm gonna have to Google that because I'm looking into him right now. I mean, I'm not gonna tell you guys what to do or not to do. If you want to do that, I'm not gonna stop you. Um, yeah, but I'm not gonna encourage or discourage that. Maybe we can't do anything, but karma will eventually get them. I think it's starting to catch up with Blake and Ryan. No judge should be a lifetime appointment. I agree. It's a weird situation and it needs updated. They should not be that untouchable. That saying that power corrupts and absolute power corrupts absolutely is so true. The more power and authority a person has, the more corrupt they get. I mean, humans, we're just a bad species. We really are. The slightest bit of power or influence that people get, it tends to go to the head and it tends to change people. And it's one of the reasons I don't this is addictive. Being on here and talking to people and voicing your opinion and people agreeing with your opinion, it gets addictive. And I try my best to not come on here every day and to keep it as a side quest in my life and keep my life as my priority. Because when I get too involved in it, I can see changes in myself. And that's just my stupid little YouTube channel. But give a guy absolute power and you're going to change that person and it's not going to be for the good. Even good people with too much power go crazy. All right, I'm going to take just a few more and then this has been going on. Where's my time? I don't even know how long it's been. But yeah, I'm going to call it a day and let you guys get about your Sunday. And thank you so, so much for spending your Sunday with me. Even though this has been very, very long, you've stuck it through and I really, really appreciate it. And I also appreciate seeing people with the same thoughts that I have and just reinforce that this is not just something that's in my head. There's something off here. So have a wonderful rest of your weekend. And if the letter gets released early enough in the day, I'll try to go live about it. Hopefully, maybe on a panel somehow. But if it comes really late, I'll probably just take it and like really look it up really good and do something with it the next day. So thank you guys so much. Happy Sunday. Thank you, Lena. Thank you. I don't know. It was Christina. I don't think Christina was here. I think Jane was here earlier. But thanks to all of you guys, and I will see you soon.